Thank you very much, everyone. I am Mary Jones, and I serve as the chairperson of the Marriage and Family Therapy Advisory Committee of the Kansas Behavioral Sciences Regulatory Board. I ask the members of the advisory committee to respond to a roll call to signify your presence at this open meeting, and that is being conducted remotely by conference call or other electronic medium. Leslie Seawester.
Here.
Joyce Baptiste.
Here.
Rebecca Culver-Turner.
Here.
John Fleeker. James Godby.
Here.
And Jardine Ingram. I note the following staff members are also present: David Fye, Leslie Allen, and Ashley Van Perskirk. I'm sorry, I always do that with your name. Sorry, Ashley. Assistant Attorney General Jana Arndt, and have I seen Lainey Bernard?
Her on the.
I'm sorry?
I do not see her on the Zoom.
Okay, at the present time, Assistant Attorney General Jana Arndt, who is assigned to the Board as General Counsel, is also present. Looks like we anticipate Lainey Bernard joining as well. Next, David Fye will read a message concerning the board or this meeting being held remotely.
My name is Dave Fye, Executive Director for the Behavioral Sciences Regulatory Board. Public comment allows the public to address the advisory committee about its concerns, but the Kansas Meeting Act, or COMA, does not require the advisory committee to provide public comment or answer questions from individuals. There will be no public comment at the meeting today to ensure adequate time for the items currently on the advisory committee's agenda. Because we are conducting the public meeting remotely by conference call and other teleconference ability, I state for the record the following information. Because the emergency declaration that was issued for the COVID-19 pandemic has been extended to March 31st, 2021, the meeting is being conducted remotely to comply with health and safety concerns, as the board's conference room cannot accommodate social distancing for everyone in attendance. However, the meeting is conducted by a system of interactive communication that allows the public without attending through the use of the conference call and on the board's YouTube channel. While the meeting is conducted remotely, the requirements of the COMA are not suspended. As such, we are conducting the meeting pursuant to COMA and KAR 16-20-1 compliance with the COMA during the existing emergency disaster declaration. January 29th, 2021, we sent notice of the advisory committee meeting to all individuals who have requested notice of the advisory committee meetings. The notice is also posted on the board's website, ksbsrb.ks.gov. You may obtain a copy of the notice at that website. An agenda and other meeting materials was posted to the board's website on the day of the meeting. You may also request a copy of the agenda by sending an email to david.fye@ks.gov with the subject line "Request for the Agenda," and it will be sent to you. The notice contains information for the conference call and YouTube channel that allows the public to attend the meeting free of charge. The notice also states that if there are any technical issues during the meeting, you may call the board office at 785-296-3240. Each member of the advisory committee, staff, and presenter shall state the person's name and title each time the person speaks or votes. Each participant to the meeting shall ensure microphones, phones, and other electronic devices are on mute when the participant is not speaking. Each motion will be clearly stated before the advisory committee votes, and each advisory committee member will vote when their name is called. The chairperson will announce the result of the final vote. The advisory committee lacks authority to delegate a member of the committee or the staff to sign any binding documents on behalf of the board, thus no such statement or motion will be made. A recording of the meeting will be posted to the board's website. The advisory committee has the following items on its agenda: call to order, approval of the minutes from December 2020 meeting, advisory committee training, executive session, old business, new business, information on the new meeting, and adjournment. The advisory committee's agenda includes an executive session. If the advisory committee elects to go into the executive session, the advisory committee will follow this process. First, the advisory committee must be in an open meeting before going into an executive session. Then an advisory committee member must make a motion to recess for an executive session that is seconded by another advisory committee member. Each advisory committee member will then vote. A majority of the advisory committee must vote in favor of the motion to exercise the executive session. The chair will announce the result of the vote. The motion must contain a statement of justification for closure and the subject to be discussed pursuant to KSA 7543-19B. And the time and place the open meeting will resume. If a motion for executive session passes, the conference call will be placed on hold. Attendees may stay on the call or return to the conference call number at the expiration of the executive session to attend the remainder of the meeting. The public will be excluded from the executive session portion of the meeting, as the executive session will be conducted by electronic means that is not available to the public. When the board members elect to return to the conference call, the open meeting will resume and the conference call will proceed. The complete motion for the executive session will be recorded in the minutes, and you should have received an email from me yesterday evening that included some items for that executive session, as well as language for an executive session motion. So when the time is right for the executive session, if a member of the committee could use that language for the executive session motion, that would be appreciated.
Okay, thank you very much, David. The meeting is now called to order, and the advisory committee will begin the discussion of the first item, which is approval of the minutes from December 2020. They were sent in your packet with the call information. So take just a second to review those, and then I would entertain a motion to approve. Would anyone like to put a motion to approve?
There I am. I will make a motion to approve the minutes as read.
Thank you, Leslie. Do I have a second?
I will second it. This is Joyce.
Thank you, Joyce. All those in favor say aye.
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 Are there any opposed? Thank you. The approval of the minutes from December 2020 is complete. The next agenda item we have is the advisory committee training, and Jana Art is here to provide that training for us. And you also should have received an email with materials.
Good morning, everyone. I am Jan Art. I'm an assistant attorney general. A little bit of my background is that after law school, I went to Wichita. I was a prosecutor for a couple of years, then in private practice. Then I became a municipal court judge for the city of Wichita. Then after that, I became a research attorney for the Kansas Court of Appeals. Did that for a little over 9 years. And then in 2007, I joined the Attorney General's office, and I've been here ever since. I'm in the Legal Opinion and General Counsel Division of the AG's office. Name pretty much gives away what we do. We work on the opinions that the Attorney General does issue. We help research and write it, and help him get it out like he wants it. The other thing is we provide general counsel to the small agencies. And so I have been assigned to the BSRB since July of 2011 it was. I've been here a while, but yet, you know, every board kind of changes and statutes and everything else changes. So it's always kind of a learning experience. The board did ask, typically we give the training to board members. We try to encourage them to do the training at least every year. This year they decided that to also give it to the committees, because you are an arm of the BSRB. So a lot of what applies to the board is going to also apply to the committee. And because you're also advising the board, I think it will help you understand in doing what you do, the assistance that you give, to understand what the boundaries and obligations and responsibilities of the board are, so that you can kind of have that in mind as you consider, you know, the things, the trends, or this, you know, what you kind of think that the board should consider. So BSRB is not anything that's unique. I'm afraid. I mean, you're a unique board, I'll say that, but you're not unique. Almost all of the professions are licensed: doctors, nurses, real estate brokers, real estate professors, barbers, cosmetologists, police officers. There's a long list of them. So each of them has a board that's a board or a commission, committee, whatever the legislation uses to create a licensing board. And the purpose of the licensing board for all of them are to protect the public. A licensing board is a police power. And so you're here to regulate your licensees and to make sure that the applicants are qualified so that the public is protected. A professional board is created by what we call enabling legislation. That is how they set it up, how many members are going to be on it, how long your terms are, what your qualifications are, and what the missions, powers, functions, tools, and enforcement abilities are for the board. So what that means is that you're a creature of statute. You're going to probably hear that from time to time. That means because the legislature created you by statute, the power and authority that you have is dependent upon those statutes. Anything exercise of authority that the board does has to come from a statute. They don't have anything that is in equity or anything like that some of the district courts may have, because they had. So you have to be able to point to a statute where you're saying, yes, the board has authorized this. And that's the only statutes that you can work with. So if it's not in an act that applies to the board, you're not going to be able to use it. The other thing that will limit a board's authority is constitutional provisions. Typically, the ones that come into power are equal protection and due process rights. Those are to make sure that people that like licensees have due process rights, that you follow those due process rights when you are dealing with whether to take action on a licensee. Equal protection would be that if you have people who are similarly situated, that you treat them equal, that you don't discriminate against one group over another. And similar thing is that your regulations cannot be vague. You can't otherwise act arbitrarily, capriciously, or vindictively. Arbitrarily and capriciously just pretty much means there's no basis in fact or law to do what you did. So when like for board members, if you're looking at a licensee, and one of the things you have to do is to consider the facts, all of it, not just for that particular case, but perhaps have they ever been disciplined before? And you have to balance that out with what is the best solution to handle that, to make sure that the public remains safe, but yet not, be vindictive against the licensee. Other things to think about that are constitutional are freedom of speech, the rights of privacy, and reasonable search and seizure. So those can also put boundaries on it. The legislature does have control over what you do. So if they were to repeal all of your enabling act, that would mean that the board would be wiped away. There would be no BSRB anymore. All licensing agencies are fee funded, which means the licensees and applicants pay fees, and then all those fees will go into a general fund, but your expenses will be paid almost entirely or partly out of the fees you're collected, and provided that the legislature does an appropriation bill so that you can go ahead and expend those money. So the other part of the board, of the things that boards have to, besides sort of their boundaries, are the language in the statutes. And that's sort of like what their authority is and is not. When you have a statute that says may, that means that you have been given discretion on whether or not to do something or to take action. That in exercising that discretion, you have to consider all the facts. So if you're going to take action or not take action, you need to sort of explain, yes, here's what happened. Yes, we have the authority and we believe that this is the correct decision, so that everything is appropriate. The other thing, and the reason that's kind of important, because it's not uncommon for boards, especially newer board members, is that they want to establish a bright line rule, so that it's something like, if this, then that. And if it says may, you cannot do that. It's giving you discretion and you have to exercise it. On the flip side, it says that the board shall do this. You don't have discretion. It's mandatory. And so, that's when they want to say, well, I don't want to do that. I want to do this. And it's like, you don't have a choice. It says shall. And then one of the things is like in an application statute, it will say the board shall issue a license to an applicant who meets all the qualifications. So if their education and age and everything, and they've paid the fee, all that applies in the statute and they've done it. You have to give them a license unless you can go over to your, what's we call the discipline statute. And there's one of those discretionary disqualifiers, such as they have a felony conviction. They have had discipline imposed, something like that, then where you are no longer out, you're no longer in the shall part of it, but you're now into the may part of issuing a license. The main overall consideration that a licensing board has to remember is that you are not there to work on behalf of the licensees and make their life easier. I mean, that, you don't want to make it overburdensome and, and not have enough licensees, but that your main purpose is to protect the public. Like I said, you're a police power. You have, that's what you're operating under. And so your whole purpose is to protect the public and not the profession. So now then the functions and duties. If you go back to your government class, there are 3 branches of government: executive, judicial, and administrative. It's the same thing in the state government and pretty much the same thing with the boards that have been created. So the first one is the executive branch. In state government, that's the governor. In the federal, that's the president. But for the board, that's the whole board as a whole, the collective. The board not one member of the board is not able to do anything. It's the majority of the board, unless of course they would have be able to delegate that to someone. So it's the whole board that makes the decision, or the majority of the board that makes the decision. In exercising their authority, they have some laws that they have to comply with, and there's a couple of them. The Kansas Open Meetings Act is one of them, which is what you're doing now. You're having a meeting under the Kansas Open Meetings Act. And so that means that if someone's requested notice of it, you have to send out notice of it. You have to make it available for them to attend, or since we're in the pandemic and that's not possible, we've had to go to electronic means to give to the public so they can attend. Open records is another thing. We'll talk a little bit more about both those acts, but it's another thing. So any record that you create, keep, maintain, possess, that can be subject to the Open Records Act, and that means the public can make a request to get a copy of it. The other type of power is the judicial authority that you have. For the committee, that doesn't really apply so much, but it does to the board. And you are exercising quasi-judicial authority. That means that typically you are making decisions on an application or on a complaint for a license against a licensee. You will be making findings of facts, determining what the applicable law is, applying the facts to the law, and coming up with a decision. So you are acting as in a judicial capacity, but you're not lawyers, so you're not a law court. You are. That's why it's quasi-judicial. But here for you, there's also, in exercising that authority, you have to follow the Kansas Administrative Procedural Act. And that basically sets forth from when, what happens once either an application or a complaint would come in, how the board has to handle that from beginning to end. The other part is your legislative authority. And for that would be for the legislature to enact statutes. For you as a board, you can enact regulations. What type of regulations is going to be dependent again upon the statutes. You have to have an authorizing statute and an implementing statute that you can that you have listed in the history section for it. In adopting it, though, you also have to follow the Rules and Regulation Filing Act. This ensures that the whole process is followed across the board. Then that they have been approved, for budget, they have been approved by the Department of Administration for style, grammar, all of that. And then it comes to the Attorney General's office and we review it for legality. It eventually goes through hearings, like a permanent will go to the Joint Committee, a temporary will go to the Rules and Regulation Board. Then after that, there's a hearing for the public, and then all of those comments that are gathered are given to the board. The board then decides whether or not to adopt it. If they do, there's a roll call vote. A certificate then is drawn up that shows what the vote is. And if it passes, then the certificate and the regulation is given to the Secretary of State, and then they publish it. 15 days after publication, then it becomes law. So that's how that's what your legislative function is because you can make law, and it's through the regulation process. So as to protect the public, we're looking at, making sure that your licensees are competent, that they're professional, and they're operating within the boundaries for their particular profession. So that means that you have to be very aware of what your statutes are and what your regulations are. And so, I can't stress this enough, is that you need to read your statutes, to familiarize yourself with them, read the regulations to read, so that you're familiar with them. And then if the issues come up, pull them out, read them again, and hopefully, make sure that you are satisfied that you have a good understanding of what the issues are and how to do that. When you're looking for regulations, you don't just want to adopt one because they're not a fun thing to do. There has to be a need for it. So that's the first question, why are we wanting to do this regulation? What's the purpose? What it is going to accomplish? You don't need a regulation to repeat a statute. You don't need a regulation to tell the board what it's to do. And you don't need a regulation that gets information out there. Your regulation, like I said, is a law. So it is to tell either applicants or licensees what they can and cannot do. The authorizing statute that's referred to is pretty simple. Well, that might be an oversimplification, but typically the language that we're looking for is it will say is that the board is hereby authorized to adopt regulations to administer, implement, and enforce this licensing act. That's usually pretty broad, and that's the best language sometimes you can hope for. Other times, though, it's not going to be that broad. It may be more specific. It may just, and the best example of that is for fees. So it will say that the board shall adopt regulations to prescribe fees for applications and license not to exceed these maximum amounts. And so consequently, then you have your fee regulation where you say what they have to pay for each type of application, each type of license. So the initial application, the renewal application, a reinstatement application, all of those are in there. The other statute that has to be in the history section is the implementing statute. That sometimes can be a little bit harder, but basically the easiest way to think of that is that it is the subject matter of the statute and the subject matter of the regulation are the same, or that it's can be implicit in the statute that the subject matter in your regulation is the same. So that's sometimes can be a little bit harder, but usually, you're not going to go drift too far from that. If you do, you're probably going to have one of the assistant attorney generals be asking you a lot of questions why you think it is an implementing statute. The Department of Administration has a several hundred page manual out there on what the requirements are for writing one. When you get ready to write one, it probably wouldn't be a bad idea to look that over to make sure it's everything's in there. There also now has to be prepared an economic impact statement. There's some other ones like environmental impact and property protections, but those are not going to apply for you. But the economic impact statement will. When they first had to do economic impact statements, the one that the first hiccup with that for the board is when they had to say which DSM the practitioners had to use. Well, when it came time they said, well, how much, the budget office says, well, how much do those cost, the book? And he goes, well, I can't remember now. It was like several $100s for one, or they can download it for like 50. And so they says, well, how many licensees do you have? And so then the budget guy said, multiplying. So, oh, well, this goes over 1 million or something. Well, that wasn't really true. And Max had to go through and kind of walk that back and explain it to him. Not everyone is licensed to diagnose, so they're not going to need it. Other people are going to not buy the book. They're going to use the environmental, the electronic version. Some people are in an entity where they may have a library that has one, and not every practitioner is going to have one. So finally, he was able to convince him to back off of that, so that otherwise it would have just stalled. If you can do what's called an adoption by reference, so that if there is another document by a private entity or by the federal government, you can adopt it by reference, but you do have to go by doing so, whatever you adopt becomes law. So you have to make sure that that document has the authority under your statutes to become law. And if not, then you either have to, then you're in your regulation, you have to state which provisions are not being adopted. And if language needs to be modified, then you have to do that as well. So they can make your life easier, but it also, if you've got a pretty long document that you're adopting, it can be quite burdensome to have to go through that, but perhaps better than writing it. So once it's been drafted and its budget has stamped everything, then it's going to go on to Department administration. They're going to make sure the regulation looks and reads like it should. It then goes to the AG's office. Once everything gets, if it gets held up, say it gets to Department administration, and the woman who does that, her name is Mary. If she says, no, this isn't done right, she's going to send it back. They've got to rewrite it. Once it's been rewritten, then it has to go back to the budget office, then back to her. Then once you get it, so she's happy, then it comes to us. If we see legal issues and say, no, there's legal issues here, you need to change it, then it goes back to get revised again. And once it's been rewritten, then again, it has to go to budget administration to us. So the process can be quite cumbersome, especially if you've got different rewrites that you have to do. And then we touched also a little bit about then once you get it to that point about how it does then go to the Secretary of State. You have to have, it gets published with a notice of hearing on the regulation, so that if anyone wants to be heard, they know when and where to appear for that regulation. And that hearing has to be within 60 days of the publication. And in the meantime, you will go over to committees that have been set by the legislature to rule it. As a permanent regulation, the joint rules and the Joint Committee for Rules and Regulation, they cannot stop, they don't have any authority to veto a regulation. However, what they can do is they're going to, they're going to ask a lot of questions, because it's usually the executive director that goes over to kind of explain it and give testimony on it. And sometimes that can be kind of a hot seat, as I understand it. I've not had that privilege, but I've heard stories. And so then what happens after that, they're going to send a letter to the person, the executive director, and say, here's all of our questions. We want an answer by this date, and you need to answer that. If they don't take kindly to being ignored. So you've got to answer it and with as much respect and say, yeah, we understand that, and we're going to take that to the board to make those changes or whatever. And the reason you want to listen very carefully to what they say, because it goes back to what we started out with, your creature statute, and the legislature controls it. So if you've done something in a regulation that they really don't like, I've seen it heard stories about two ways. One is some of your budget may get cut, or two, that statute gets cut. Because if your statute goes, so goes the regulation. So that's why, and I think 99% of the time, I think boards work with the legislature committees to get it so that they're happy with it. Sometimes the legislature goes, we didn't realize there was an issue here. Maybe we need to go into that statute and amend it, make it better. And they will do that too. So sometimes it's a good thing to get that feedback, because it's kind of a give and take. The other thing is a temporary reg. It's the same process, but it goes to a different legislators. It goes to the joint board. They a temporary reg, you have to. It's only good for like 180 days, and then it's expired unless you can get it renewed. But you have to show that it is also to the joint committee, not to the AG's office or anyone, but to them, you have to show that it is in the public safety that this temporary reg gets adopted. And because it doesn't have a public hearing and it's effective upon publication, it becomes law much quicker. And that's why you need to show that there's a real need for that regulation. That particular board does have the authority to veto it. And if they say, no, we're not going to approve it, then you're done. You've got to wait until you can get a permanent reg in there. One example of where they've said no is that they were trying to do a temporary reg to increase fees because they were going to be running out of money. And they said, no, that is not public safety. That's because of bad planning. So, like I said, it becomes much easier if you're familiar with them. You also aren't going to get overturned on appeal if you know all of your statutes and are familiar with them. And reread them as all you can. I guess I kind of jumped over policies. Policies, that people have a tendency to kind of get those confused. Policy is typically what you adopt that tells, gives directions to staff or tells procedures. The most common one is like almost all agencies have on their website like a discipline investigative committee policy that explains to people, like when we receive a complaint, here's how we're going to process it. It goes to the investigative committee. The investigative committee looks at it, determines, if there's anything to it. They continue the investigation and so on and so forth. Another one policy that's on there is your open records policy. That's required by law. A guidance statement is basically to kind of say that this is the way to guide your licensees or the public. This is kind of the way that we do it. There are requirements for how to do guidance documents. They're not as many guidance policies as there are. There's not as many guidance documents as there are policy documents. Let's see, the other things as applies probably to board members and the committee members it was going to be like conflict of interest. And conflict can be something that's personal, financial, direct, indirect, or engaging in some other type of business activity that would not be in line with what you do for the board. So one thing might be, and this is sort of like where I start off, that, when you're on a board or you're on a committee, you're like everyone else. You have different hats that you wear. One's going to be as a board member. One's going to be as a licensee. One might be as an employer, and you might belong to professional associations and be active on that professional association. So you could wear in your life many hats that impact what you do as a professional. But when you have to remember that when you're coming to the meetings or you're doing anything on behalf of the board, that's the hat you need to have on, and you need to leave all your other hats at home. So that's, and sometimes you will see this when you have a board member who's very active in the professional organization, and the professional organization is trying to push all of these changes through. And then so that person comes to the board and they go, hey, this is a great idea. I want us to do it. It's sort of like, okay, that's great for the profession, but what is this going to do to the public? So take off that hat and tell us how this is going to, if this is something that is going to increase public safety or not. Other things would be, a career, you don't want to do something like a discipline licensee just so that you don't have so much competition in the area, things like that. If somehow you know someone or have heard something about someone, so you have a bias that you can't be objective, that would be another type of a thing. It can even be as much as that, your next door neighbor or your employer has a relationship with a licensee that, has a case pending, and you think that, you can't handle that. That doesn't mean though that you should, you have to really see, can I set that aside? It shouldn't be a get out of jail card that you can say, I can't do this. You have to really search and make sure, can I be impartial about this? Of course, if it's financial and stuff, it's probably not to even do that appearance of a conflict and get out of it. Confidentiality. You're going to come across information that's confidential as your role as a board member and perhaps even as a committee member. And the confidentiality stays with you not just while you're on the board, it's also after you leave the board. So once you leave, you still have to protect and keep that confidentiality. The two types where these are most common is going to be during executive sessions. So that you have two types of executive sessions for your board that would come into play. One is for personnel. You're going to be discussing some of your staff. It might be rather embarrassing. You want to protect their privacy. And so that's why you discuss that out in executive session, so that the public doesn't really need to know what the issues in the office are. The other thing that you would do an executive session for is for legal counsel. You have an attorney-client privilege, and to keep that attorney-client privilege, you have to have an executive session, because if any third party who's not a part of the client is in there, then that violates the attorney-client protection. Whatever you discussed is now can be discovered. So so that's sort of, make sure that if you're going to go to an executive session that you really need it. What you don't want to do is then when you come out of an executive session, then start saying, well, when we were talking about this, what was the point? If you're going to come out in open meeting and start talking about it. So just remember that you don't want to have the executive session and then come out and start discussing what's going on. Sorry, I thought I had that off. So the other thing is about the executive session, don't discuss afterwards, but if you do reach a consensus in executive session that you want to take some type of action, then you need to make the motions and have the motion. You can do you have to be very limited, be careful what you say during the discussion of the motion, but you can come out, to take the action and vote on it and pass it, so that because you cannot make a decision in the executive session. You can reach a consensus, but not a decision. So there's no vote during the executive session is kind of the main way to think about that. The other thing that is confidential are going to be your deliberations. Deliberations are not executive session. That's when you're under the Kansas Administrative Procedure Act making a decision on an application or on a discipline matter. And this is just something that it's because it's in a quasi judicial capacity. When your decision, if people want to know why you did what you did, that has to be explained in an order. And if people want to know, well, why'd you do this? Your answer is go read the order. You don't say, well, Joe thought this, Jim thought this, Susan thought this, and we decided we'd split the hair and do this. That's not what you want to do. That you need to protect those deliberations so that everyone is comfortable in having a good decision, a good discussion on how to do that. They're not going to be fearful of what may be said afterwards. It's the same thing with the judges. When they make their decision, what they discussed is not subject to discovery at all. It's like, if you want to know, you read the opinion. Ex parte communications. This is typically going to be in a matter of when you are involved in a pending matter involving an application or a licensee. That means ex parte is just simply that you cannot have conversation with someone, about a party without both parties there. So consequently, you can't, as a board member, you can't say, well, here's an application. I know this was their supervisor. I'm just going to call them up and ask them some questions. That's not allowed. you can't get on the internet and start Googling things, because when you have a hearing, your decision needs to be made on the information that was presented at that hearing or that's in the record. And it's just very simple. It's because you don't want someone making a decision based on evidence that's been kept a secret from you. You want to be able to they need that due process so they can present their side of the story. And it just means that you're also being fair and objective to everyone that you have to deal with. Let's see. If somehow you do think you need to talk to someone about a matter, then that's easy. You can do that, but you need to do a procedure. You need to get the parties together, and if they're represented, the attorneys there, and have that discussion and ask your questions and see how to handle, and then that way there can be free discussion among everyone about it. If somehow you do trip up and you have an ex parte conversation under the CAPA, you do have to disclose that, and it needs to be put in writing and on the record who it, when, where, how it occurred, who it was with. And then that's given to the parties. And then if one party feels that you are no longer impartial, they can make a motion to have you disqualified. Professional activities, we've kind of already touched upon that. It's just one of your hats you can wear, and you need to remember that. The other thing I might say that it doesn't happen very often, because to have a meeting, you have to have a majority of the people there. But so oftentimes board members will go to professional meetings, and that's fine. And people will see that there's several there, board members conversing. And so they think, aha, they're talking about board business. And you may see a coma complaint. So consequently, make sure that if you are at a social gathering with other board members, it's not that you can't talk, just do not talk about board business. Keep it about the weather, whatever, or something else other than what you would be talking about at a board meeting. Once in a while, you will be asked to speak either before a legislature or again to a professional association, maybe to a Rotary Club, something like that. And so that's fine, but you just have to remember that, especially if you're before the legislature, to let people know that you are there in your personal capacity. You are not there as a board member. The only way you can speak on behalf of the board is if the board would vote and a majority says, we want board member Smith to present our viewpoints, at this meeting or at this hearing, and then they can do that so that everyone understands that this is the position of the board, or this is the position of me personally as a citizen. So there's nothing to say, we're not taking away your rights, as a private citizen. It's just you have to make sure that everyone understands which hat you're wearing. COMA requires that all meetings be open to the public. That's so that everyone is informed about what's going on. The requirements for openness are liberally construed, and the exceptions are narrowly construed. So you really have to make sure you fit into one of those exceptions if you close out an open meeting. Because you are a subdivision of the board and you do receive some funding in whole or part by the public funds, that puts you under the COMA as a committee. The COMA doesn't apply if you're doing, some agencies are not under Kansas Administrative Procedure Act. So if they have hearings, they have to have their deliberations. There is a statute that says if they're conducting quasi-judicial deliberations, then that's not a part of an open meeting, so that you don't have to go through and have that out in the open. COMA will not apply to the judiciary or to private organizations or staff meetings. So like when, say, a board member would show up for a staff meeting that David's going to have with everyone there, that's not a board meeting, that's a staff meeting. Now, if the majority shows up, that would be something else, but those are usually okay. The board meeting is a gathering or an assembly, and you don't have to be in person. You can do it by telephone or any other means of interactive communication. And it's by a majority of the board. So depends on how many, and it's not by the board members in attendance, it's by the makeup of the board. So if you've got 12 members that comprise the board, then you're going to have 7 people there in attendance to conduct any business and have the meeting. If it's less than that, then you don't have a meeting. And the purpose of the meeting or the gathering is to discuss the business affairs of that board. So it's not to have a Christmas party, but if you do have a Christmas party, make sure you don't discuss the business of the board. One thing about the thing is that when we say electronic communications, that can also include emails. So, and it's, oftentimes we will send, you'll get an email to address to all of you, and there's typically a warning on there and that will say, warning, do not reply all or discuss this amongst yourself, to avoid a coma violation. And I usually have that in red ink, bolded letters, so it stands out that this is something that's informational only. It's just so that you have knowledge of this, but you're not to be hit reply all. And you're also not to be calling each other up. You're also not going to respond back to. Another way you can say is like, okay, I don't hit reply all, but I hit reply back to David. They go, well, David, this is the way I feel about it, and this is what I want to see done. Well, then David adds up all the emails and he sees, oh, here's how 8 of you want to do it. And he says, okay, well, this is what you guys decide you want to do. That's what I'm going to go do. No, you can't. Now you've violated coma. So it's the same thing. Before you had emails, it was called a calling tree. It would be the same type of thing. You would call one member and discuss it, and then you would call another member and discuss it. And then once you called a majority of them and you knew what they wanted to do, then you take action on that. That's another way to do it. A majority can be different for a quorum, and you see quorum used still. Up until a few years ago, the COMA read that it was a majority of a quorum to hold a meeting. So if you had 12 members, and a quorum was half, so it'd be 6, and a majority of that would be 4. So getting 4 people together was a meeting. So you had to be very, very careful what you did. So what the legislature did several years ago is they took out that quorum language. So it's now the COMA just says it's a majority of the board. Discussion, as I said, it had to be a discussion of board business. So that doesn't mean that you take any action or that you vote on anything. It's that you discuss it. It doesn't matter what you call the meeting or the gathering. Sometimes you'll see retreat or a work session. It's the same thing. If you're getting together, then it's a meeting, no matter what you call it. Notice is required if someone has asked it. You don't have to publish it on your website. You don't have to publish it in any newspaper or the register. But if someone says, hey, I want to be notified about your meetings, and then that's what they have to do. Then notice has to be reasonable. So typically you'll take all the considerations into that. If something happens where, like right now, this time of the year, the legislation is pending. And so you may have to have a very quick meeting to discuss the legislation so that you can provide testimony about it. So it may not get a week notice. You might be lucky if they get, a 24 or 48 hour notice. And that's okay because under the circumstances that would be reasonable. The notice does typically last just for 1 fiscal year, and executive directors, usually you'll see something come out in July and says, hey, if you still want to receive this notice, you need to tell us, otherwise we're going to drop you off. But if you don't make that request, then you can't drop them off. But if no one requests notice of your meetings, then it becomes very simple. You can hold the meeting as you can get everyone together because no one's requested it. The other, I have to step back when I say it doesn't have to be published. Governor Collier did issue an executive order that said that all agencies had to post their notices of a meeting on the public square. And so there's no penalty if you don't, other than you might upset someone, it's public squares where all agencies post. So it's sort of a one-stop shop. If you want to know what meetings are going on, you're supposed to be able to go there. The other thing that boards will struggle with, especially when you get enough new board members, is they want to know, well, how do we follow Robert's rules or something else? No, there's no requirement on how you conduct your meetings, so you can develop that. And I always strongly advise, do not follow Robert's rules. They are very strict. They are very, if this, then that. And if you vote this way, then you can't go back on it. You don't want that. I mean, you want to be able to consider something because it's necessary for you to make a decision or to have a discussion, and you want to do that. You won't, and you have to know, like, you have to have like a parliamentarian, and you have to know who has this authority and that authority. And if some issues arrive, they'll turn to me and ask, well, what do we do? And I go, I don't know. I said, Robert's rules is not a law. It's something that you want to follow, then you're going to have to figure out how to follow it, because it's not law. It's also to buy the book. It's not a cheap book. So the COMA does not require you to have an agenda. So you don't have to do that. But if you do it, then you have to make it available to everyone who wants it. You also, you don't have to mail it out. So a lot of times, they can request it after or during the meeting, whatever. The public can attend, but that doesn't mean they can be disruptive. So they can be asked to leave if they do become that. They also think public has a misconception that they have the right to speak, because most people do have a public comment session on their meetings. So people think they have that right, but they do not. They just have the right to listen and to observe. You cannot vote by secret ballots. And usually that's mean you write it down on a little piece of paper and you hand it in, and then someone just opens them up and looks at them. There is an old agey opinion, and I will tell you, do not follow it. It says that, yeah, it would be okay if on a little piece of paper they wrote their vote, if they signed it, and then they could turn that in. And then if anyone wanted to know how people vote, and it would become a record, and then you would have to keep it under your record retention policy. And so if someone wanted to come in, then they could pull those votes and look at it. No, I don't think you're going to find anyone that would agree with that opinion. I can't remember. It was written probably in the 80s or early 90s. It's old. But I mean, if the public's right is to be able to observe, that means it's to be able to observe the vote, not to have to go in later and to read the votes. So I caution about doing that. Don't do it unless you want to welcome a COMA complaint. You are not required to keep minutes unless you go into an executive session. In a couple of years, they changed it so that it's always been you have to have the executive session in minutes. However, they've changed it so that executive session pretty much has to be verbatim made, verbatim as to the language that it was made in. So that's why I have, if you will let me know, I will write up the executive sessions ahead of time so that they can be read, to make sure that, because there's a requirement of what has to go into the executive session. And so that way, hopefully we get it right, and that's okay. So the motion has to be made, second, and carried. It has to contain a statement, attorney-client privilege, but you have to kind of discuss then tell them what the subject's going to be, but you can't reveal the confidential information about it. And then the justification, which is in the statute, the time and place then that the meeting is going to be resumed. And then again, that complete motion has to be recorded and permanently retained. I think we've already discussed some of the stuff, other stuff that's coming on. Another thing that has happened in the past is an agency will get a legal memorandum from their attorney, and so to give them legal advice. Well, then they're having an open meeting and they'll go into executive session because they want to discuss that legal memorandum, and that's their basis then is attorney-client. Well, that's if the attorney is not present in the executive session, you're going to be in violation. It can't be to discuss the attorney's legal memorandum. It has to be, the attorney has to be there. So that, because that's, you're receiving confidential legal advice, and so that they're there to give that to you, not so that you can read it. But the biggest complaints are going to be executive sessions. The public usually don't like them. The motion for an executive session wasn't made. They came out of executive session and discussed it, or later on discussed it. Someone who was not a board member was in on the executive session. They didn't reconvene on time. And serial communications, which again is that calling tree or emails type of thing. The one exception to emails, and I always say, I hate to always say exceptions, but to discuss a date and time for a meeting, that's not really anything that they're talking about interactive communication about the business of the board. So yeah, you can always, when you're trying to set a date, a time and place and date, that's okay. And then notice, again, notice is a big one. Your notice, you have like a generic email that goes out for all of your meetings, your board meetings and all your committee members. And so I think everyone, regardless of how they wanted notice, they all get the same email. Prosecutions can be brought under the COMA. It is a civil action. It's not a criminal action. Any individual or a county, a district attorney, or the attorney general can bring an action in district court for any violations. The courts are supposed to give precedence to COMA cases and get it resolved as early as practicable. If they get the complaint filed quick enough, a district court can void any action that's taken. They can do an injunction, which means to stop it. A mandamus is to force you to do something, or they can just make a declaratory judgment and say, this was right or this was wrong. The penalties can be, this is where you, if you're starting to doze off to kind of wake up, penalties can be up to $500 fine for each violation per board member. Now this, I said board member, or in your case, committee member, because it's not the state and it's not the board that pays the fine. It's the person. So you got it. You're going to be reaching into your pocket. They can also remove you from office, and really egregious instances, they can assess court cost and attorney's fees. So that's why it's really, they can even assess a court, assess attorney fees against someone for bringing a frivolous COMA complaint. A new provision that was added several years ago was to give the attorney general a little bit more power. We can now go in and do a consent order or issue a finding that there's been a violation. And those type of things, they have to contain the findings of fact. And they the penalties there, they in lieu of a fine, they may require you to do training that has been approved. The fines are not quite as steep. It's just up to $250 for a violation. And then you have to agree that you're going to start complying with the COMA. And then you will also have to provide proof that you have complied with everything that you were supposed to do on the consent agreement, and everyone who violated it has to sign that agreement. So it can't be like David signs on your behalf. You have to personally sign that agreement. It's a preponderance of the evidence, so it's not that difficult to meet. They also, the Attorney General can also do investigations. They can issue cease and desist orders and stuff. So if you are notified that there's been a complaint filed, you need to let David know, and he'll let me know so we can get working on it and get a response back, because typically they may ask you to give them more information, so you will need to respond usually within a short amount of time to tell them what happened. You're not required to self-report. Some people think that if you realize that you stumbled and made an error, then it's better to report rather than to have someone else report you, because you're taking acknowledgement of that, but you're not required to. So it becomes your decision on whether or not you want to do that. That's, like I said, just kind of, it's your comfort level, I guess. And if it's, if it was egregious, I would say then you probably definitely should report, because then it shows that, you're remorseful or you acknowledge it, you're taking responsibility. The more egregious, then probably, well, one, it should never have happened if it was egregious, but it shows that, you kind of came to your senses and you're not going to do it again. The Open Records Act is the next thing. There's a Record Retention Act, which means that anything that the board creates, receives, possesses, maintains is a record of the board, and that can't be disposed of unless it's done pursuant to a disposition policy. And that disposition policy is something that has to go to the Historical Society and be approved by them. And it can be quite a process to get rid of some records. Usually they're destroyed. Some records have to be shredded in order to comply with the law when that happens. But once you have them, then they're also subject to core, because that's now a record that is open to the public. And so the public can ask for a copy of that, or they can ask to come in and look at it. And so when that happens, the first thing you have to do when they make a request, you're going to see, well, do we have such a record? And if you do, then you have to look at it and say, okay, yeah, but there's a lot of stuff in here you can't see. And then you have to either label the stuff that can't be disclosed or will have to be redacted, which is just blocking out the information they can't see, but they get the rest of the document. The time that staff can be charged to the person who's requesting it. They can also have to pay for all of the cost and the mailing fees for it. The one thing to remember about an open records request is that when you get that, that you need to act upon it within 3 days. You have to basically say, yeah, we received it. And, if you have it, you can turn around in that 3 days and send it to them. That's great. But if not, you say, we've got it. We'll start looking for it. We'll let you know what we find out. And we'll let you know then, what the next step in there, so that you're kind of keeping them apprised of it. Let's see, probably what else? Oh, public records, you don't have to create a record. So if they're wanting information, you don't have to answer their questions. You can say, CORE doesn't request us to start answering all these questions. It also doesn't require you to create a document. So if they want something, and yeah, you could go through everything and create a document to give them what they want, you're not required to do that. So what is a written record? It can be, like I said, anything you possess. It doesn't have to be in paper form. It can be in electronic form. It can be something that's stored in a computer data. So and again, it's like for a public agency, so it's not going to cover a private person, and it has to be related to the operation. So if you've got a personal email, it's not going to cover that. I think Leslie, I think, is the information officer. So she gets the person who's probably going to get these letters, and then she's probably going to hand them off to Cindy.
Yes.
And then
Never possible.
if she can, especially when they have to do with discipline. There are certain things that you do not have to hand over. I mean, the biggie one is like something that's prohibited by federal law, and that is a Social Security number. That if you disclose a Social Security number, there can be fines assessed, several $1,000s. So it's always best to make sure that you search every document very carefully to make sure that always gets redacted. Personal identifying information is another one. Your transcripts that come from the colleges on applications, FERPA protects those. So those cannot be given out in a CORE request. A person can make a request verbally, but you can say, no, that's fine. We'll be happy to take your request, but you need to provide it in writing. and tell them, need to provide in writing, give us your name and your address. Sometimes you can ask them for proof of identification if they're saying these, because if something's confidential and they're saying I am that person, then you need to make them prove it up. And then if they're asking for like a mailing list, then they also have to agree that they are not going to use it to solicit sales or services, because that is a crime to do that. And our office has prosecuted some people who have violated that in the past. You also cannot give them copyrighted materials. So they can come and read the copyrighted materials or listen to it, but you can't copy it for them. Let's see. When we talk about this, because we said it's also electronic, that snags in your emails. Several years ago, it was discovered that there were some individuals that were trying to get around this. They were using their personal emails that were on their private servers and not on a state server. And so it kind of became apparent that that was a little bit of a loophole. So the legislature went in and changed it so that it doesn't matter. And they said it doesn't matter where that's stored, as long as it's about the business of that agency, then it's a record. So to get, if you are, some boards have created email accounts for their board members, but it's very expensive. And then a lot of board members don't like it because it's just one more email that they got to check. So one other thing I should say is that they also gave the power to do a search warrant on someone's personal computer to search for records. And so you don't want someone coming and saying, here's a search warrant, we need to have your computer. The best way to handle that is when you're discussing board business, then to CC someone at the board, such as David or Leslie, because by CCing them in there, then a copy goes to them, that will go to the server. And so by going to the server, then when they do a search for a CORA request, then that's going to get picked up. And they can say, yeah, we've got emails on that. So that's why, well, one, you shouldn't be having emails about, between just yourselves about your business. But if it is something, make sure that you have David or Leslie, someone in the board as a part of that group or going to them, so it will get picked up. Discretionary stuff that can be closed or personnel records, your medical records, treatment records, your personal information, which is like your home address, your home email, your home telephone number. A lot of times it's like your maiden name, your mother's maiden name, date of birth, that kind of thing. Okay, so now then, let's see if someone makes a CORA request and there's been a violation. Here's the good news. This one you do not pay out of your own pocket. This will be paid by the board if there's a violation. If you believe that something should have been closed, then they disagree, then it can go to a district court or we call it an in-camera review, and they can look at that without revealing what it is and make a decision on whether or not it should have been released. It's pretty much the same type of thing. An individual, a DA, a county attorney, or the attorney general can prosecute. The attorney general also has new authority about being able to do consent agreements and to issue findings of a violation. And pretty much the same thing, same type of thing for the COMA. So I'm not going to go through all of that. The Kansas Administrative Procedure Act really isn't going to apply to the committee, but it will definitely be something for the board members. And that is going to be applying to applications and to complaints. Prior to CAPA was something that was enacted in the late 80s. Before that, everything was done under COMA. And almost federal government and probably almost all the states have this now, some type of Administrative Procedure Act. And so that was an old agey opinion that said, well, even though you're under CAPA, you're also under COMA, so you have to conduct it in an open meeting, which, becomes cumbersome. And then in 2009, the legislature put an amendment in the CAPA provision for hearings. It says a hearing is not an open meeting. So that means if it's not an open meeting, then you don't have to comply with CAPA. And then there's another statute that says proceedings to make probable cause or procedural issues do not have to be held under the hearing statute. So that meant that basically nothing, we looked at an opinion request was made back in 2014. We looked at the two acts and said, no, these are mutually exclusive. Their purpose is entirely different. The open meeting is to inform the public. The Administrative Procedure Act is the due process for an individual. So they're not the same purpose. They're not about the same thing. What happens about a particular person is not something that the entire public has an interest in necessarily. So that was good because now boards, when they're under CAPA, you don't have to worry about, making some kind of COMA violation. So that's helpful. The only thing, as I said, that does have to be, even though a hearing is not a meeting under COMA, it is still open to the public. They still have to be able to observe it. You can close it, like in some instances, the law allows you to close it, you can close it. So if it was something came up about trade secrets, you can close it to discuss trade secrets. If it's about medical records, you can close it off to the public to have those discussions or to get that evidence. All of your acts are under the CAPA. It used to be that each act was always a little bit different, and they were so it was very difficult to keep in mind when you had so many different acts and when CAPA applied and when it didn't apply were different. It was just a disaster and a real it was just an accident waiting to happen for COMA violations. So several years ago, we went back into all of the acts and we changed them so that it has the following provision. It says administrative proceedings and disciplinary actions regarding licensure under this licensing act shall be conducted in accordance with the Kansas Administrative Procedure Act. So they now all read the same. And that's been a big boon, I think, to all the board members, especially the discipline or the investigative committee. The only one warning that is different, and because it was the board was not involved in this legislation, it was something that was a last minute bill that the board didn't have any input on, is the Behavior Analyst Licensures Act. And I think it was even passed after we made these changes. And theirs reads a little different. It says any action taken under this section which affects any license or imposes any administrative penalty shall be taken only after notice and opportunity for hearing conducted in accordance with the provisions of the CAPA. Luckily, we don't have too many behavior analysts, and I don't think we've really had a lot of issues on their applications or with discipline, so we don't have to worry about interpreting that. But if we ever do, we're going to have to take a good hard look at that and figure out at what point you're under CAPA. Either that or to at some point, not this legislative packet, but something way down the line to go in and get that language changed so that it mirrors the other acts. The other thing that's different from COMA is the CAPA doesn't require notice goes out to the public. So it's just the notice is typically going to be to the licensee and the licensee's attorney, and like to Jane, who's the litigation counsel for the board. So they don't need to see how you vote for probable cause or anything else. So you just kind of have to remember what's under CAPA and what's under COMA. Some, like the investigative committee, they may actually conduct both COMA and CAPA. So that if they have a COMA, they're going to be discussing general broad issues such as should we develop ask for legislation to change this, to change our discipline statute, something like that. That would be COMA. And so consequently, that would require notice to the public. And then if there's agendas to do that, and the same thing with minutes and executive sessions, that would all be under that CAPA or coma, excuse me. But then when they switch over, then they can adjourn that open meeting and then switch into the CAPA, and then they can discuss the complaints that they have and discuss those without the public being a part of it. So you kind of always got to make sure, which act you're under so that you make, you have a clear understanding so that you think you're under CAPA, but you should be under coma, and then you violate the coma. CAPA, if you really can't, other than like ex parte communications or something like that, you don't really violate it. So there's not going to be like a penalty as there is under the coma. Applications, they're handled a little bit differently because the board is not doing an investigation. They're not trying to do anything. It's someone asking to be implied. So that person has the burden of proof. However, though, once they grant the license, even if they put a condition or a restriction on it, that person has a due process right. They now have a property interest, and that's what gives them this due process right. So from then on, if you do anything to try and take action against it, that's why you have to go through and make sure you've got the authority to do it, and then that you follow all the procedures to do that. Even if you were to give them a license, but to restrict it or condition it, then you have to give them the notice and opportunity so they can address whatever restrictions that you've imposed. We've covered a little bit about investigations and a probable cause determination. Once they make that determination, then they have to decide what to do. If they're going to issue a warning letter, if they're going to issue an order that puts them on probation or conditions or anything like that, or if they're going to suspend it or revoke it, then typically they can do that by either doing a summary proceeding order or they can file a petition. I think almost always now agencies have learned that it's best to just go ahead and do a summary proceeding order. And the reason is because that if they don't request a hearing within 15 days of mailing that summary proceeding order, then that becomes a final order and you don't have to have a hearing. But if you file a petition, then you're going to have a hearing. And so you are creating more work for yourself by doing the petition. But if you do the summary proceeding order and they do request a hearing, then that summary proceeding order becomes your jurisdictional document. And, if you do a petition, here's kind of the pros and cons. If you do a petition, you can amend a petition. You can't amend an order because that's it. And so you're going to hearing on the order. And so the violations and the issues are pretty much going to be what is going to be in the summary proceeding order. So you have to make sure that you haven't left something out of your summary proceeding order if you think there's should be more than one issue. The CAPA also has what's called emergency proceedings, and that is if you feel that a licensee is really going to be an immediate, imminent danger to the public, you can go ahead and suspend their license without going through all of the formality of all this and waiting till all your investigation is done and giving them an opportunity to be heard and all of that. What happens, so if you do the emergency, then that is immediately appealable to the district court. And district court can decide if this was truly an emergency or not. And while that is pending in district court, though, the board still has to be continuing on with an investigation and making sure that they do finally gather everything they need and then to proceed on. And so that if it's not resolved through a consent agreement or something, that you go on and have the hearing so it can be resolved about whether or not they need to continue to be suspended. Both sides have the opportunity to do discovery. So that means they can interrogatories, requests for admissions, they can have depositions, all of those things so they can figure out what the facts are. Once they have pretty much completed their discovery, then there's oftentimes going to be a pre-hearing conference. This is if you do a petition or they request a hearing, things that will go on before the hearing. They have a pre-hearing conference where they try to narrow down what the disputed facts and the disputed law is, and so that the hearing officer knows pretty much what the issues are going to be. The board can act as a presiding officer, or they can appoint certain members to be a presiding officer. That is why the committee is not the full board. They have given that authority as a presiding officer to the investigative committee. Some agencies, almost every licensing agency has some type of investigative committee. Some have also, for applications, also done an application committee who will look at all their applications, or one board member to look at the applications, especially, those are usually like larger boards or where they have a lot of applications. It just takes too much time. They get too bogged down in doing applications. So it gets delegated down to some of them. CAPA proceedings can be very time consuming, and the meetings can be very lengthy. So I think kudos to anyone who's on the investigative committee, because you're carrying a heavy load there. There's just no way around it, and you're doing a lot of hard work. So people need to be really ready to commit to that time. So I think that's great that they have stepped up and said they're going to do it, because, you can get hundreds of pages to read and then be, 3 or 4 hours at a committee meeting. And then like whoever gets to sign the orders has to look them all over and read them and stuff. So it's nothing to take lightly. Once you have your hearing, then if it's over at the Office of Administrative Hearings, they issue a final, what's called an initial order. And that initial order can be appealed to what's called the agency head. The agency head is essentially the whole board, unless the board has delegated to one or more members to be the agency head to review that petition for review and make a decision. Are you going to review it? If so, you have the parties file briefs. After briefs, then you make a decision and you file a final order. They would also decide if anyone after the final order makes a motion for continuance or a motion to stay the effectiveness of that order. So that's why delegations can be kind of important, because for a petition for review, you've got like 20 days to make a decision on whether or not you're going to review it. So you have to go very fast, not just to make that decision, but then to get an order out on whether or not you're going to do it. So again, that is something else that a lot of boards will go ahead and have a delegation for someone to be the agency head, or a committee to be an agency head. However, the people who are on the investigative committee cannot be an agency head, because they have already, that would be like under the definition of ex parte, they have had communications with the prosecutors and other people. And so they are no longer a neutral party, because they've already made decisions. And so they are excluded from being an agency head. Presiding officer conduct is much like a board conduct conduct. You don't want to have ex parte communications because you have to remain neutral. And especially kind of like what I was going about before, as a presiding officer, like all board members for applications are presiding officers. And so that's why you're not supposed to be going out and digging up your own evidence, looking stuff up. You have to wait until you get to the hearing and see what the parties present and see what the agency record is about. If someone doesn't show up at a pre-hearing conference or at the hearing, the board can take a default, or the presiding officers take a default judgment. Basically, what that means is it just says whatever's in that summary order or what's in that petition is deemed to be true and correct, and it's adopted by reference. And so, however, the person does have the opportunity within like 15 days to file a motion to set it aside. If it's set aside, then you go ahead and have a hearing. If not, then if it's denied, then that default order becomes a final order. Again, once you have a final order, then it's next step is someone can file a petition for review with the district court. The district court is limited in what the basis they have to reverse an agency's decision. The ones you usually is the top one goes back to what we've always said, is that you didn't have the statutory authority, or what you did was unconstitutional. Um, the other thing that is usually happens, most of them are based on number 7, which is that their factual findings are not based upon substantial competent evidence when viewed in light of the record as a whole. So that is why you have to make your findings of fact so that they know that you did look at everything that was presented. And then when you go down into your analysis, you have to say what the law is and apply it so that they understand how you made that decision. And then they can say, yeah, you had the facts that showed that was a violation. And so you do have substantial competent evidence for your decision. And the other one, and this is kind of a Hail Mary, I think everyone throws this in, is that it was otherwise unreasonable, arbitrary, or capricious. But, if you had the facts and you had the law, it's not going to be unreasonable, arbitrary, or capricious. So those are the things. We are, when it's the whole board or a board, if you were to have a committee, I am usually there and present, for the hearings and then for the deliberation, so I can answer questions and I can listen to them and see what it is they discuss and make sure that they're getting all of the facts they need out there. And so that if I help them draft the order, I know what's important and what's not important and how they applied the law. And a lot of times if I can't, and I don't know how they're getting there, I'm going to ask questions, or if after I do research, I may come back and say, here's something else I found. We need to discuss this a little bit more, because I'm there to provide you the legal advice that hopefully we can get an order out there that if it is appealed, it's going to be upheld. So far, the last case we had, the district court reversed us. We were confident we were right, but we complied with the district court orders. We went on up to the Court of Appeals, and the Court of Appeals said, no, the board had it right. So that's our purpose there, is to make sure you get it right. The Kansas Tort Claims Act, we kind of finished with this one. It's kind of an important one, but it's probably, hopefully, the last act that you really don't need to worry too much about. When you're a board member or a committee member that the board's set up, you are subject to getting sued. Can you stop anyone from suing you? No. If they're going to sue you, they're going to sue you. But the main thing is, if you do get sued as a board member for something that you did as a board member, as a committee member, to immediately let us know. You can, David, if you're not sure, get a hold of David and he can help you out. But you have to let the Attorney General's office know, because if you get a hold of us timely, you ask for representation and you give us a copy of the petition and the service of summons, then we can represent you and present your defense. So, you can be liable for anything you do, but there are some kinds of immunities, and this is goes right back, and I guess I want to also point out, yeah, you get us and you also get us for free, and I'd like to think that you are getting more than what you pay for. So that's why, and we like to make, we've got experience with handling cases when board members get sued that a lot of private attorneys don't have. So I think you're going to be happy I don't think it's ever going to happen, but I think you'll be okay. This gets back to you. What is it that you have to do in order to get that protection under the Kansas Tort Claims Act? You have to show that it occurred within your scope of duties as a board member or committee board members. Okay, keep that in mind, because what does that mean? We're looping back up to where we began at the very beginning. Always make sure that you have the statutory authority to take the action that you took, and to make sure that it was impartial, make sure that it followed the law, and that was it a may, so that you had the discretion and you looked at everything and you used your discretion in making that decision, or was it a shall? I had a shall, so I had to do this. I didn't have any choice. So that is what, that's how you get our representation. That is how we present the defense, and that is how you can escape any kind of liability. So that's why I stress over and over when people say, I want to do this. My response is often going to be, well, where's your statute? Right, Leslie? You go, what statute are you looking at? Tell me, where are we at on this? Okay, well then give me a regulation at least so I can work backwards, if not forwards. So that's why, because a lot of times what you'll hear back is, well, there's no statute that prohibits us. Like, no, that's not the question. It's not what prohibits you, it's what authorizes you. So that's why that comes back in play. The only other thing, again, is that when you also have to cooperate with us in your defense. So don't be blowing us off if we're trying to set up depositions or to have a conversation with you about, like, tell us about what was going on here. Also, that when you did act, that you weren't doing, maybe you had the statutory authority, but you didn't have any fraud or malice. It wasn't, you weren't trying to get back at someone. One other thing I would say, and this rarely happens, but it does. I mean, we're here for a purpose, and that is to give you legal advice that we think will keep you out of this litigation. And so if you follow our advice and it ends out that something happened that wasn't the best advice, or it was wrong, something intervening happened, we can still defend you. And because you followed what we told you to do, so it wasn't your fault. Then what would happen would be, like, it doesn't get you out of liability, but that becomes a defense saying, we didn't have malice, we didn't have fraud. Here was our attorney's advice. We followed the attorney's advice. That becomes your defense. It will mitigate damages. The flip side of that is that if we say, don't do this, you're going someplace you should not go, this is too risky, you're going to get hit with a violation, and you go, I don't think so, or like, well, I don't care, I don't want to do that way. Well, what you're going to see then is we're going to make a note of that. We're going to say, well, this is the advice we gave you, and you said, I'm not going to follow it. Then what happens if that lawsuit does come about? They're going to say, well, Jan, why did they do this? What did you tell them? And I'm going to say, this is what I told them. They can decide, if you're not going to take our advice and we were right, then we have the decision on whether or not we want to defend you. Because it's not that we're blackmailing you. It's that what's our purpose if you're not going to follow our advice, and then you come around and say, well, now I want your services to defend me. So, and if you don't understand why we're giving you the advice, make sure to ask us, explain it, because sometimes we have a tendency, to give a shorthand answer, or maybe to use legal mumbo jumbo. So just always ask if you don't understand. And then the big rules is that, again, not only asking for representation and giving us information, but these are the two biggies. Is once you've been served, or even if it's pending, you think you're going to get sued, do not sign anything and do not say anything. Let us talk for you once you get hit with a lawsuit. Anything else? Anyone have any questions? I mean, that went a long time, but I need to find a way to cut it shorter, but I want to make sure everyone has a pretty good idea of what's kind of going on, because there are a lot of people just think that it's, the licensing acts is all they got to know. And there's not. There's so many more acts and laws that apply to agencies that you need to be kind of aware of the bigger ones.
Does anyone have any questions for Jan? If we do, after people sort of digest, should they just contact you directly if they have questions for follow-up?
Okay, let's go back to the training on Cora. To get legal advice, that has to be in an open meeting and done in an executive session. So the problem becomes, so it's a majority. If one of you were to email me, and it would not be a majority or two, but I have a problem, then if all of a sudden I'm getting several emails, I don't want to create, and I just said, don't do emails like that. So consequently, my preference is that you contact David and say, hey, I would like Jan to come back and address this. I've got more questions, and then I'll be more than happy to come back to any meeting and answer any of your questions. that email stuff can get in telephone stuff where you keep talking about, because training is a part of it, has to be in an open meeting. And to go get legal advice has to be in an executive session. Executive session requires an open meeting. So that gets to be the tricky part.
Okay, thanks for that clarification.
Yeah,
Because it's a lot. We're digesting a lot
I know
today.
it is. And that's why I put it in writing so that, you know,
Yes.
you can go back and read it.
Okay, hearing no questions or comments, then I'd like to move to the next section of our agenda, which was the executive session. So if I could get a member, or if one of the members of the committee would like to move to executive session, there was language sent to you.
I have it queued up here if you'd like me to do it. I just need to know, how long are we thinking?
Well, we have a hard stop here at 12 at noon. To maybe 15 is what I was thinking.
Okay.
I'll see if we can, yeah, hopefully speed through it real fast.
Okay. What time is it? I'm trying to look here.
It is 11:40 right now.
11:55 is good enough. Hold on. Pursuant to KSA 75-4319, I move that the Marriage and Family Therapy Advisory Committee recess into executive session for 15 minutes and reconvene the open meeting at 11:55 a.m. The meeting will reconvene remotely by conference call at 1-877-278-8686, PIN number 327072, and at the link to the board's YouTube channel as stated in the notice of meeting that was sent to individuals who requested notice and published on the board's website, ksbsrb.kansas.gov. The justification is consultation that would be deemed privileged in the attorney-client relationship with the board's legal counsel, Assistant Attorney General Janet Arndt. The subjects to be discussed in the executive session concern the Kansas Open Meetings Act during the disaster emergency declaration. Board staff who are included as the client in the executive session are David Fye and Leslie Allen.
Okay, can I get a second for that motion?
I second.
All those in favor, please say aye.
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 Any opposed? Okay, I will ask that you disconnect this Zoom call and that we would refer to the executive session conference call number provided. Thank you.
turn the video too. Is it sitting
Hi, it
up?
looks like we are just about back. I'm just checking the roster here to resume the open meeting.
Okay, thanks.
And it looks like we have all of the advisory committee members originally who started the meeting, with the addition of Jardine, who came into the meeting during the training. Advisory committee members, was there any business to take as a result of the executive session? Any motion? Okay, hearing none. Then I'd like to go into back to the agenda in terms of old business and new business. And in consideration of the time, I'm wondering if the advisory committee would be good with tabling old business items to the next meeting, or any new business items to next meeting.
Yes, that's fine.
I'm in favor of that. I did want to ask about whether we.
Oh, we froze up, Jardine. There you
Can
go.
you hear me?
I can.
Yay.
Yay.
Okay. I wanted to ask if we could discuss the, if this is in our purview, the licensing or the licensing application process. I feel like I'm hearing from the community that that's just happening very slowly. And I'd just like to have an update on what's going on there. So if that could be for new business for next meeting, that's fine.
Are you referring to brand new applicants or
Yes.
transitioning applicants? Okay. We could definitely add that to the agenda.
Leslie can explain that process of what she does with what happens to applications when they come in, because they can't really do anything until everything is in and it's all complete. But she can explain that, because it's not anything that happens in a week or two. That's a short end of the story.
Did we
Okay.
pick a date yet for the next meeting?
That will be the next agenda item. So we've been
Oh.
on this. No, that's great, Rebecca. You're moving us right along. We are typically meeting every other month is what we agreed upon. So the next date would be looks like April 9th, Friday at 10 a.m. Does that date seem to work for everyone?
Works for me.
Yes.
Yes, works for me.
Works for me.
Great. Okay. If there's no other business, then
Mary?
Yep. Yes.
Leslie,
Okay.
are specific people we're looking at, or is it just in general?
Jardine, are you looking for general information, or do you have specific inquiries that need to be referred to Leslie?
Was that for me? You cut out. I'm sorry.
Yes, yeah. I was asking if you wanted general information about maybe the application process at this point, or did you have a specific inquiry that you wanted to get to Leslie?
Probably just questions about the length of time it's taking for applications to be processed, and are we very delayed? Are we on time for what people should be expecting?
Okay.
I know, yeah, that kind of thing. I guess does that help?
Yeah, definitely. I want to pull a file if it's someone specific so I can figure out what's going on. But if it's just general, I can do that too.
Yes, it's more general. Thank you.
Okay, sure.
Okay. Thank you for that clarification. So if there's no other business, then I would accept a motion to adjourn.
I move to adjourn.
Second?
I can second that.
All right, thanks, Jim. All those in favor?
I
Aye. Thank you all so much.
Thank you. Thank you for the
Next time.
training. It was very informative. It's a lot of information.
Yes.
Very
Thank you.
informative.
Thanks.
Okay. Bye, everyone.